Good evening. Welcome. My name is Michael Berger, and I am the Executive Director here at the Sabin Center for Climate Change Law and a research scholar and lecturer at Columbia Law School. I'll be your moderator for tonight's panel discussion, Can Fossil Fuel Companies Be Held Liable for Climate Change? The question matters, and it matters now. We are already living in a world where global average temperatures are 1 degree Celsius or 1.8 degrees Fahrenheit warmer than they were relative to the period between 1880 and 1910. The effects of this, and I should point out that this global increase in temperature corresponds with a global increase in average carbon dioxide concentrations in the atmosphere. And we are on a pathway where in the long term we will be looking at concentrations of carbon dioxide and other greenhouse gases and temperature increases that are even further outside the historic range of the entirety of our known civilization and history. The effects of this are evident here in the United States and all around the world. This weekend will mark the 5th anniversary of Hurricane Sandy, which hit several islands in the Caribbean quite hard, ravaged the eastern seaboard of the United States, destroyed neighborhoods and crippled infrastructure here in New York City, and made impacts as far inland as Appalachia and the Great Lakes, resulting in an estimated 160 deaths and an estimated $72 billion worth of damage in the United States alone. 1 year after Sandy, Typhoon Haiyan hit the Philippines, killing an estimated 6,300 people in the Philippines and causing an estimated $13 billion in damages. And this fall, of course, we have seen Hurricanes Harvey, Irma, Jose, and Maria hit Texas, Florida, the Gulf Coast, Puerto Rico, and numerous Caribbean islands. All of this causing several hundred fatalities and hundreds of billions of dollars in damages, as well as the individual suffering of people who are dislocated from their homes, exposed to toxic releases, recovering in place without power or water, and so forth and so on. At the same time, and we've also seen the historic wildfire season in the area out west, causing similar types of damages and destruction to communities out west. So at the same time, many areas all around the world are experiencing slow onset changes as a result of climate change. Glaciers are melting from increased temperatures, coastlines are disappearing to sea level rise, areas are experiencing desertification. Some coastal communities in Alaska and Louisiana have already begun to relocate. Small island states in the Pacific will likely be entirely submerged. This is the world we're in. Climate change impacts, including both the extreme events of increasing intensity and frequency and the slow onset events, and the synergistic effects on human communities are happening now, and they are only expected to get worse. Those who have benefited from the social and economic systems that have produced this reality are best prepared to withstand and adapt to it, while those who have benefited the least are very often the most vulnerable and the hardest hit. So the question that arises is, who should pay for all of this? This is obviously not a new question. The issue of loss and damage or international compensation for climate change has been under negotiation since before the signing of the United Nations Framework Convention on Climate Change in 1992. The idea that common law torts might provide an avenue to redress is also not a novel one. The first common law climate change action in the United States was filed in 2004 in a case called Connecticut versus AEP, when states, cities, and environmental groups filed complaints against the nation's 5 largest power companies, claiming that their greenhouse gas emissions were a public nuisance under both federal common law and state common law. The plaintiffs in those cases were seeking an injunction to have the court order a reduction in the emissions from those 5 power companies. The case eventually went to the Supreme Court, which held in an 8-0 decision that the Clean Air Act had displaced any federal common law public nuisance claim that may have existed. The state common law claims were not addressed directly by the court's decision and were not pursued afterward by the plaintiffs. Meanwhile, another federal common law public nuisance suit was winding its way through the Ninth Circuit in native village of Kivalina versus ExxonMobil, a community facing relocation due to sea level rise and other climate change impacts, sought monetary damages from a number of fossil fuel companies due to their direct greenhouse gas emissions. Following the Supreme Court's decision in AEP versus Connecticut, the Ninth Circuit held the claim displaced. There's one other common law suit that bears mentioning here, and that's Comer versus Murphy Oil, where individuals who suffered property losses and other damages from Hurricane Katrina sued a number of companies, seeking compensation under several state common law theories. The case has a famously messy history, but the short of it is that the key issues of standing, the application of the political question doctrine, statutory preemption, and causation were left fundamentally unresolved. All of which brings us to today. And again, the question, who should pay for this? The continuing shortfall in climate change ambition, the leadership vacuum in the White House and at the Environmental Protection Agency, revelations regarding the extent of industry knowledge about the nature of climate change and its impacts, and coordinated efforts to cloud the public debate and delay government action, advances in the science of climate change attribution, and the continuing onslaught of climate change impacts have all contributed to a diverse group of petitioners and plaintiffs going to court to hold a particular set of fossil fuel companies to account and to seek to hold them liable for climate change. In one instance, the Philippines Human Rights Commission has launched an investigation of the so-called carbon majors to examine whether their climate change contributions constitute a violation of human rights under Philippine law. And in two separate sets of cases in California, a handful of cities and counties are seeking compensation from fossil fuel companies for the costs of adaptation. Tonight's panel will address this question. Can fossil fuel companies be held liable for these damages? In something of a moot of prospective arguments. We'll hear first about the science of climate change attribution from Peter Frumhoff, who is the Director of Science and Policy at the Union of Concerned Scientists. We'll hear next from Sharon Eubanks, who is a partner at the plaintiff's firm of Bordas & Bordas and a veteran of the tobacco litigation, and she'll share some of that experience with us tonight. And she'll be offering the argument in favor of holding for liability. Next, Tom Lorenzen, a partner at Kroll and Mooring, and a former attorney in the U.S. Department of Justice, will argue against liability. And finally, Professor Gerald Torres of Cornell Law School will offer some of his thoughts on the ideas and arguments surrounding this issue. We will hold some time for Q&A at the end, and we will finish at 8 p.m. With that, I'm going to turn things over to Peter Frumhoff to give us some of the background on the science.
Thank you, Mike. Good evening, everybody. It's a real pleasure to join you here tonight. As Mike mentioned, it was 5 years ago, actually, 5 years ago this Sunday, when Sandy, going up the East Coast in the Atlantic, took a sharp left turn westward and slammed into New Jersey and New York and did tremendous damage. Now, there's a lot we can say about the causes and the consequences of that storm. It's very difficult for a variety of reasons to pinpoint exactly whether the severity of the storm, the probability of the storm, its track, how that was affected by climate change. But there are some things we can say about the damages and the role of climate change in exacerbating the damages. And I want to show you a little bit about that as we talk about the role of attribution science in informing, not determining, but informing the question of fossil fuel company liability. So a study that was done a couple of years ago looked at not the probability of the storm affecting New York, but given that it hit New York, how much greater damage in terms of storm surge occurred as a consequence of sea level rise. we've seen global average about 8 inches, 20 centimeters of sea level rise, a little higher on the East Coast. And a group of colleagues at an organization called Climate Central did a study in which they looked at how much damage would have occurred if there had been no global sea level rise, no anthropogenic-driven rise in sea level, and how much could be attributed to that increase in damage, increased storm surge associated with sea level rise. So what you see here in this slide, the blue is the area that would have been affected under any conditions, absent the human impact of sea level rise. The orange or that red color are the areas that were flooded only as a consequence of the additional rise in sea level, the additional storm surge. And of course, with human sea level rise, those blue areas, you can't see it from this graph or from this figure, are also deeper. That is to say, the level of sea level rise is also greater and therefore more damage. They actually quantified this and put an economic number on it and calculated that of about $12 billion of damage from storm surge associated with Sandy just on New York City alone, that sea level rise, anthropogenic sea level rise, human-caused emissions, increased the damage by about $2 billion. That's a couple $100 per every citizen of the city of New York. New York's also done really important work to look at the future costs of climate change in terms of the cost of adapting to change that's already occurring and that will continue to occur under current projections. So a study that came out in 2013 by a team of climate scientists, actually the best work done, in my view, in any city in the U.S. and perhaps in the world, looked at climate projections, looked at impacts projections, and calculated that it would, what that would look like in the 2020s and the 2050s, and put a price tag together with the city Plan NYC of about $19.5 billion in preparation costs to adapt to both rising seas and more extreme heat and changes in precipitation. So it's a legitimate question, in my view, to ask, as Mike Berger asked, who should pay the cost? The default assumption is certainly in the U.S. that the taxpayer picks up the costs, or the affected communities. This is from Sandy, from Harvey in Texas. The affected communities who often don't have flood insurance, that they're paying the costs. Communities, taxpayers, that's the default assumption in our country today. But it's legitimate, in my view, to ask the question, as this sign so provocatively does, that was posted in Houston a couple of weeks ago, when will climate polluters, in this case fossil fuel companies, pay their fair share? Now, I want to argue that science can inform this question. It can't determine the outcome. But in my view, it's a legitimate question to ask. It's essentially the question at the table for us today. So I want to say a little bit more about what science can tell us. As Mike mentioned, there's a body of climate science called attribution science that looks at the impact of climate change on the changes in the frequency and severity of extreme events. The first study was done just about 13 years ago after the 2003 European heat wave, which some of you may recall, average temperatures in Western Europe, particularly in France, were about 10 degrees Celsius warmer than they had been in the previous years. It was the greatest heat wave on record since probably the late 16th century. And it led to something on the order of 70,000 excess deaths. Tremendous heat-related mortality across Western Europe, and particularly in France. A study came out the next year. Basically what it did, a very simple, kind of cartoon-like version of looking at how you look at the probability and the change of an extreme event, simply by running models, climate models of the world with and without warming, with and without the human emissions that are driving increased temperature, average temperatures, but also shifting the extremes over as well. And you can ask, what's the probability of an extreme event? If it's a 1 in 500-year event under typical conditions, does anthropogenic warming make it a 1 in 100-year event or a 1 in 50-year event? How does it change the frequency of an extreme event of a magnitude such as we saw in 2003? And basically the study that came out in Nature in 2004 characterized that it's very likely, probability greater than 90%, that human influence, our emissions, has at least doubled the risk of a heat wave exceeding this magnitude. So it doubled the risk, at least, of a heat wave of the magnitude that we saw in Western Europe in 2003. And in fact, in an interesting commentary at the time that I don't think many people noticed, a news commentary in the same magazine, a writer noted the implications, the legal implications of this. They said the results of this study could make it easier for groups attempting to sue large emissions producers for the damages caused by global warming. So the very first study of climate attribution was taken up, at least in a conceptual way, with respect to the question of liability for damages. We've simply gone back actually and done further work. This is a paper I was a co-author on last year, and coupled the attribution study of the probability of that extreme event with heat mortality models, and are able to characterize, as we do here, actually how many deaths in, say, the city of Paris can be attributed to the increased extreme heat associated with human-caused warming. And we found that, for example, out of the 700 some odd deaths attributed to the heat wave in the city of Paris, that about 500 of them could be attributed to anthropogenic climate change. We can actually put a number on the probability of deaths resulting that would not have resulted had we not had human-caused climate change driving the increase in the extreme event. So this is not necessarily something we can easily monetize, but it's of course very real. So that's the nature of attribution science. There's another dimension to this as well, of course, which is the question of what companies knew and how they responded to that knowledge, and what can science tell us about that. There's good evidence from a variety of sources that since 1980 at least, perhaps earlier, companies, for example, the American Petroleum Institute and all of the companies associated with it, ran a task force to monitor and share climate research, that they were well aware within many fossil fuel companies, oil and gas companies, coal companies, of the risks of climate change, that their own scientists were reporting it to executives. Many companies, including through the American Petroleum Institute, were engaged in a campaign of disinformation. This is from an internal communications memo that came out in the late 90s when the Kyoto Protocol was being debated. A multi-million dollar, something like a $6 million campaign that became released in the New York Times shortly thereafter, which highlighted that victory would be achieved when average citizens understand or recognize uncertainties in climate science. The campaign was to sow doubt about the risks of their products in order to avoid regulation, work that Columbia School of Journalism and many others have well documented. And science can tell us something about this too. So this is a series of advertorials that were in the New York Times from ExxonMobil, really from the late 1990s through the 2000s, all highlighting uncertainties or presumed publicized uncertainties in climate science. A public campaign to represent the state of the science as ExxonMobil wished us to see it. A couple of colleagues at Harvard, Jeffrey Supran and Naomi Orestes, just in August published a study in which they compared the content, through a content analysis, social science analysis, the content of the advertorials with respect to whether they accepted climate science, whether they highlighted that it's real and human caused, versus what Exxon scientists were publishing in academic papers and reporting in internal company memos, and found that something like 80% of the studies that were in the academic journals by Exxon scientists and the internal company documents highlighted and accepted the risks of climate change, acknowledged that it was real, and something like 80% of the information in the advertorials highlighted doubt about the risks of climate change, highlighted uncertainties about climate change, and they concluded from their study that ExxonMobil contributed to advancing climate science by way of its scientist academic publications, promoted doubt about it in advertorials, and given this discrepancy, we conclude that ExxonMobil misled the public. Again, a dimension of the question of responsibility, at least in an ethical sense, a question for whether that implies legal responsibility. Finally, I want to turn to the question of whether we can specify the contributions of companies to real climate damages. A colleague of mine, Rick Heady, in about 2013, published a study. He went back and calculated the amount of coal, oil, and natural gas extracted from the ground on an annual basis by individual fossil energy companies, coal, oil, and natural gas companies, a few cement manufacturers as well, and characterized how much of the carbon dioxide and methane that's been released to the atmosphere since the dawn of the Industrial Revolution, since the middle of the 19th century, can be traced to the refining, extraction, and the marketed products of individual companies. What he found to me was extraordinary, which really got me focused on this body of work. The blue is an annual measure of the amount of industrial-sourced carbon dioxide and methane globally from all sources. And you can see how much it's increased every year until this just goes up to 2010. The red is the amount that can be traced to the products of just 90 companies, 90 fossil fuel companies and a couple of cement manufacturers. About 2/3 of all industrially sourced carbon dioxide and methane that's been released to the atmosphere since the dawn of the Industrial Revolution can be traced back just to 90 companies. By the way, about 60% of these emissions have resulted since 1980, since companies clearly knew of the risks of their products. We just recently extended this work, working with Rick and a number of other colleagues, to translate this into real changes in climate. So we took Rick Heaty's data on annual emissions, we incorporated it into a very well-established carbon cycle model. Industrial sources of emissions are only one source. There's also deforestation, also methane from rice paddies and other sources of emissions that affect climate change you have to take into account. That's what climate models do. We quantified and measured the differences in changes in climate, global surface temperature, sea level rise, with and without the emissions from these 90 companies. And we compared the results for their emissions from since 1880, since the data start, and since 1980. It might be a kind of a proxy for responsibility as a start date, just to throw that out as a kind of a way to think about the question of responsibility and potentially liability. I'm going to very quickly walk you through what we found. So, as Mike Berger mentioned, we've seen about 1 degree Celsius increase in global average surface temperature so far, more to come. Just under 50% of that can be traced to the products, the activities of these 90 fossil fuel companies. And if you look at their emissions since 1980, just over this 30-year period, about 1/3 of the rise in global surface temperature that we've seen can be traced to the emissions just of these companies. And we can break it down further. This is where it gets interesting to me. So we can look at the percent contribution of the rise in global surface temperature that can be attributed to the activities and products of individual companies. So this just ranks the top 20 from largest to smallest in terms of their total emissions. Chevron's at the top. This is for the rise in global surface temperature, and you can look through and see both names familiar and perhaps less familiar. Include state-owned companies as well as investor-owned companies. And this is essentially the same data looking at sea level rise. So the 3 largest contributors in terms of their historic emissions to the sea level rise that we've seen are Chevron, ExxonMobil, and BP, and then Royal Dutch Shell. Again, a way of characterizing quantitatively the contribution of the emissions from their products to real changes in climate. And by extension, we can, of course, anticipate, and this is work to be done, that one can trace this back to specific damages in specific places if we wish to do so. It's kind of a proof of concept that that approach is feasible. And finally, of course, it's not just the changes we've seen so far, but there are more changes to come locked in by inertia in the climate system and future changes that can be traced back to historic emissions. So again, for example, a very conservative approach in our study, we looked at how much future sea level rise we might expect to see that can be traced just over the next couple of decades back to the emissions from these 90 companies. We've seen about 8 inches global average sea level rise so far. The rate of increase in sea level rise is increasing, and we expect to see conservatively another 5 inches in sea level rise just from the historic emissions of these top 90 companies over the last couple of decades. So a lot is locked in terms of their contributions to current and projected changes and associated damages. So I'm at the Union of Concerned Scientists. We're a science-based advocacy group. We work to translate science into forms that are accessible and compelling to public understanding and public policy. We haven't traditionally worked in the legal realm, but we're interested in making sure this science is relevant both to the question of whether companies, the social license of companies to operate, as well as their legal license. And I'm really delighted to be able to then hear from our legal colleagues in terms of not just the notion of this in the court of public opinion, but the relevance of science and attribution science in particular in the court of law. I'll stop there. You could turn this off. Oops.
sure there's a way to do it.
Okay.
Good evening, everyone. Thank you for inviting me. It's great to be with you here. I'm going to get right to it. Litigation. It's a good thing, all right? In fact, in this case, I look at the idea of litigation is actually using the legislation that we have. I want to go back and I want to be very specific about this, but the advances in science that we heard about from Peter that we have, the advances in climate science regarding attribution, the ability to link greenhouse gas emissions to quantifiable increases and to temperature rises, sea level rises, and extreme weather, they make litigation more practical, not just more possible. My background is from tobacco litigation. I was lead counsel for the United States in a civil RICO case that was filed in 1999 that's continuing to this day. I think that there are several different avenues of litigation that could be approached here, but the one I want to talk more about is the tobacco litigation in comparisons with what I see as possible climate change litigation or climate lawsuit. Bear in mind that those of you who are lawyers and law students know that in addition to RICO theories, we've talked about state consumer protection actions might be a possibility. If every state has a consumer protection law, that might be one way to go. We heard a little bit, just in mention, of possible nuisance actions at the state level. California has several cases that are pending. And in terms of the next wave of litigation, I think we also would look at, various tort claims that might be asserted, and in particular also financial types of claims that are being looked at in New York Attorney General's office at this point. New York laws are there's a unique statute that gives rise to a possibility of some liability, climate liability, that as I'm familiar, no other states have. But let's look at the similarities that lead me to the conclusion that a racketeer-influenced and corrupt organizations Act case, or RICO case, is something that's a possibility because it's been done before in a very similar situation. I'm going to use the example of ExxonMobil, not to exclude the others, but their documents are the ones that I'm more familiar with because they were released several months ago by an organization, Inside Climate News, that did an extensive report on what they had found. And the similarities between what they had found and the actual tobacco litigation and the ultimate findings in the case that was decided in 2006 are so similar that it just makes it seem like a very natural fit. And as with the law, precedent is important. If you've been there before, going there again is something that is a lot easier to do. So you don't have to be the first, and you wouldn't be the first. Bear in mind that the author of the RICO statute, Robert Blakey, said it's not just for blue collars anymore, it's for all kinds of criminals. So, and some of these actions under RICO, which has civil provisions, making it a lesser burden of proof, is something that is good to look at and to think about. We certainly thought about that when we did the tobacco case. We filed tobacco with 3 different statutes in mind, trying to recoup the health care costs for treating sick smokers. The court dismissed those 2 statutory aspects of the case and left standing only the RICO claim, which actually simplified a complex case a little bit. It was a 9-month trial. There were specific findings of fact that came out as a result of it. And it was a case brought by the United States. However, RICO also has provisions. It is a statute that can be used by private parties. There are different remedies that you get depending on whether you're the government, the U.S. government, or the state. I don't think that there's any likelihood that Jeff Sessions' Justice Department is preparing a case right now, but it takes a while, and thinking about it over time might be something that would play out in some time. We didn't file the tobacco litigation overnight. That's something that took a little bit of time to do. In fact, the United States government in its lawsuit was way behind the times. The states came first, and I think we're seeing that as a wave right now with California, some of the state AG's investigations. It's coming. I'm not saying be patient, but I'm saying that, as you know, as you wind your way through the courts, each case builds on what you learned before, and how you use that precedent is something that is important to the next case and keeping it in mind. So let's look at, I said I wanted to focus on Exxon. Exxon funded climate denial long after its own scientists knew and determined that the climate change was real. They knew it, and then they hid it. We looked at those, what did you call those?
Advertorials.
Advertorials? Whatever. Those are the things that they filed, that they put forward in newspapers, mail fraud, wire fraud, whatever. They put them in newspapers, statements that said, oh, we don't really know yet, it could be something, but it's not, the science isn't all there, when they knew that otherwise it was. ExxonMobil's misinformation campaign was not conducted alone. And this is the key fact of RICO. It's enterprise. It's a group of even loosely connected individuals or companies or organizations committed to the same goal and carrying it out together. So they did not conduct themselves alone with this, but they associated with groups and organizations to carry out their message of doubt. Exxon misled investors and the public about the risks of climate change. And this was all about the bottom line. It was all about money. To prohibit new regulations, they've lobbied to prohibit new regulations that might be costly to the petroleum industry. And they kept at this for quite some time. And it would seem are continuing to this day, which is another aspect of RICO, that the actions that are going on have to be continuing into the present. And you can't just erase what you did. There's also a neat provision if the federal government brings the case that you don't really have to worry about the statute of limitations issue. There's no statute of limitations, interestingly, in the RICO statute itself. However, the Supreme Court said, you know what, it's 4 years. It's not in the statute, but that's what they said it is. That's for private claims. So there may be some benefit to doing a case that is, a federal government case, or looking at those claims and figuring out whether there are limitations, problems that can't be overcome. I mean, when you undertake an idea like a huge lawsuit, this would be a huge lawsuit, you don't just wake up one morning and say, whoa, I'm going to go down to my computer and write that complaint I've been thinking about. It took us many, many months to put together the tobacco litigation complaint, even though we had the wisdom of the documents from the states. And that's one of the other things that accompanies the research that Peter was just telling us about. We have documentary evidence from the company's own files about what they knew and when they knew it. That doesn't present an issue of plausible deniability then, now does it? It's kind of bad for them, all right? So that's good for the side that wants to bring a case. When we brought the tobacco litigation, when we came forward with it, we carefully considered whether there was an actionable basis for a lawsuit, and we're very careful about doing it. And I want to say that that's one of the things about the Justice Department, or at least it was when I worked there, that you're very careful and you want to follow the law. It's not just a name, it's a profession. Justice is supposed to be what you're bringing about. How did we get to that? We had tried, we the people, had tried legislation to deal with some of the issues that the companies were engaged in, some of their behavior. But that legislation came to a screeching halt when the companies asked for one thing too many that they weren't going to get from the legislators, and that was immunity from all lawsuits. Lawsuits are a good thing. They make people do the right thing sometimes if they don't want to. And as long as you're following a statute that gives you plenty of precedent about how it works and what it means, it's not that hard to take some time and effort and people to come together and figure out what would that lawsuit look like. What would a RICO lawsuit look like against the industry? Who would the defendants be? How would you write about what the enterprise is, the group who's working together to do this, and move forward with it? I have been surprised not to have seen such a lawsuit pursued at this point, because I know it's complicated, but typically law is complex. It's not always that straightforward, and they make you study it for 3 years before you can go out and practice it. And when you're practicing it, you still don't get it right because you're practicing it. So, there are things that you learn along the way in any presentation. But I want to leave you with something that speaks louder than myself about these issues. And it's something that actually a senator gave me this, and a U.S. senator. And he said, I want to talk to you about why this is so. He said, in your case, U.S. versus Philip Morris and others, Gladys Kessler, the judge, gave this description of culpable conduct in her decision in the government's racketeering case. Each and every one of these defendants, she wrote, consistently, repeatedly, vigorously, and falsely denied the existence of any health effects from smoking. He lines that up with his own assessment in the climate area and says, each and every one of these defendants repeatedly, consistently, vigorously, and falsely denied the existence of any adverse climate effects from carbon pollution. He moves on and he says that, moreover, in the tobacco litigation, Judge Kessler writes, they mounted a coordinated, well-financed, sophisticated public relations campaign, those advert things, to act and distort the scientific evidence demonstrating the relationship between smoking and disease, claiming that the link between the two was still an open question. He writes, moreover, they mounted a coordinated, well-financed, sophisticated public relations campaign to attack and distort the scientific evidence demonstrating the relationship between carbon pollution and climate, claiming that the link between the two was an open question. And he concludes with, defendants knew, in the tobacco case, Judge Kessler writes, that there was a consensus in the scientific community that smoking caused lung cancer and other diseases. Despite that fact, they publicly insisted that there was a scientific controversy and disputed scientific findings linking smoking and disease, knowing at the same time that their assertions were false. He writes, defendants knew that there was a consensus in the scientific community that carbon pollution caused climate change and other harms. Despite that fact, they publicly insisted that there was a scientific controversy and disputed scientific findings linking carbon pollution and climate, knowing their assertions were false. So I'm saying we've already been there. There's a blueprint for a RICO lawsuit that could be brought. And it's something that I think should be considered to make the companies provide equitable relief, which is something that would have to be thought about. What do you do to fix it? It's not just about suing just for the sake of suing, although I love a great lawsuit more than most people probably. But it's not about that. It's about what the ultimate result is and what's at stake here. And I think a bunch of smart people could figure that out and could, put together a pretty good lawsuit, a strong lawsuit that might bring about some change. Lawsuits are often settled. Ours wasn't. Goes on to this day. But, bringing parties to the table to discuss these matters and to figure out some resolution to save the planet is not a bad idea. And if you have to litigate to do it, more power. Thank you.
All right, the defense. A couple of caveats before I start. First of all, every view I express today is my own. They're not the views of my law firm, Crowell & Moring. I should note for you, I am not representing any of the parties in any of these litigations, and I am also a substitute speaker called in about the last week to replace someone else, so I don't have a pre-PowerPoint. But there are some points I want to make here that I think are important here. I think it's quite notable that the courts that have addressed this so far have not been so ready to entertain these suits, with the exception of the Juliana case, which is its own sort of unique creature. But in both the Kivalina and Comer cases, the courts expressed, I think, serious doubts about whether this sort of case is really amenable to resolution by the judicial system. And that, I think, is the fundamental problem here and the fundamental difference between these climate-related tort cases and the tobacco cases that the Department of Justice, my former alma mater, so justly pursued. We're talking about a product that is not used by you and maybe you in the back based on your response to advertising, but we're talking about products that we all use. Every one of us is sitting here in a room that is lit. Every one of us is listening to my amplified voice. Every one of us got here in a car or on a bus or on a train. Do any of you abjure all electricity? Any of you? Okay. No one. We are all, in that sense, responsible for this alleged damage, for the sea level rise, for the damage to the land, and I'm not going to come up here today and debate whether climate change is or is not happening. That's not my role. I didn't bring a scientist. My personal belief, again, not the belief of all of my clients, is it's happening. But is this something that the courts are really suited to resolve? How does one determine who are the victims? What is the class of victims? It is everyone. What is the class of tortfeasors? It is by the same token, everyone. Because we are all in this together. And this has been the basis for the court's rulings so far that have dismissed these suits. In the case of the Kivalina lawsuit, the court ruled that the the claims are displaced by the Federal Clean Air Act and by other statutes. In the Comer case, it was questions of standing and political question, and also preemption. Let's talk about political questions for a moment. What are political questions? Typically, as I sort of said, they're cases where we're really all in it together. And it's not easy to identify who are the plaintiffs and who are the defendants. They are cases where there's really no judicially manageable standard. If we impose liability on BP or on ExxonMobil or on Arch Coal, what is to stop them from impleading every one of you as a defendant who is also responsible for the damage for having used the product? There are also cases where allowing a court to try to resolve it would really show insufficient respect for another branch of the government. Here, Congress. Congress has had many opportunities to address climate change. We had the Waxman-Markey bill. It failed for reasons that may be valid, that may be invalid, that we may agree with or disagree with, but it failed. We had the Obama administration's efforts to tackle climate change through existing authorities, the Clean Air Act. I was actually one of the authors of the first suite of climate change regulations, the motor vehicle greenhouse gas rule, the ill-fated tailoring rule. And we saw President Obama go further during his second term with the Clean Power Plan, attempting to regulate greenhouse gases under Section 111. That is a regulation whose fate still sort of hangs in the balance. It is out there at the D.C. Circuit, unresolved. The new administration, a duly elected administration, is undoing that. What weight should that electoral choice have in resolving these tort claims? Is that electoral choice the political question that the courts feel reluctant to intrude upon? And if we are to go down the road that Sharon has suggested, with the court fashioning equitable relief, what is that equitable relief to be? Are we going to have our federal district courts or our state courts directing, as is now being asked in the Juliana case pending in the District of Oregon, federal policy, directing that we limit or end the burning of fossil fuels? Is that a question for the courts to be resolving in lieu of our electoral processes? The political question doctrine tells us no. That is not something that the courts are suited to addressing. That is for the legislature. That is for you at the voting booth. That is for all of us to resolve through those electoral means. There are some other issues that I think we need to address here. And I didn't bring a scientist with me today. I think Peter makes some very good points about improvements in climate science and attribution science, but there is still a very difficult question here of attributing particular climate-related damages to individual defendants or even to groups of defendants. And again, I ask you, what about all of you as defendants? Where are you in this? The fact that these companies produce these fossil fuels would mean nothing if we didn't all consume them, all of us. I think it's notable that during the Kibalina argument in the Ninth Circuit, Judge Sidney Thomas asked of one of the counsel, I drive a car. Why am I not a named defendant in this lawsuit? I think that was quite telling in the court's ultimate resolution of that case. And then finally, we do have the issue of preemption. I do want to mention this because I think it's an interesting issue here. It has been the law of the Supreme Court since the American Electric Power versus Connecticut case, a case that I worked on when I was at DOJ, that EPA's statutory authority under the Clean Air Act, passed by Congress, does displace federal common law nuisance and other claims that might be brought. And it is the existence of the statutory authority, not the actual exercise of the statutory authority, that works the displacement. We as individuals may agree or disagree with what Administrator Pruitt is doing with the Clean Power Plan. Should it be enforced? Should it be rescinded? Should it be replaced if it is rescinded? But no matter what they do, the statutory authority to regulate greenhouse gases under Section 111 and under the PSD provisions and potentially under the NAAQS provisions and other provisions of the statute remains, and that displacement will remain. By the same token, the state law claims that are being brought are, interesting. We don't have resolution of those yet. They are not displaced by the federal common law. The Third Circuit has held so in Bell versus Cheswick. Other circuits have also held the same way. But there is a parallel question of whether those state law claims are displaced by state authorities. State constitutions, state statutes, state regulations. We don't have the answers to those yet. These are difficult questions that have to be answered before I think the courts are in any position to address whether they have authority to regulate just under preemption. Put aside the political question. I think those are the points that I wanted to make tonight in my opening, and I look forward to your questions and to further debate on this. Thank you all.
I guess I'm supposed to bet cleanup, we'll see. The issues that have been raised, of course, are in some ways the previous speakers were talking past each other, and so I want to talk a little bit about that. But then I want to focus on the role of litigation itself. That is whether litigation is in fact the proper vehicle for addressing these problems, and what role litigation plays not just in resolving the issues, but in what role litigation plays in the political process as well. Right, because if you reflect, and here I want you to step outside the framework of environmental litigation or even climate change litigation, and think about the major changes that have occurred in your lifetime that have transformed the society in which we live. You could, for instance, during the civil rights revolution, have said that the resolution of the problems facing African Americans is really a problem that is best dealt with through legislation. And that, in fact, trying to litigate these issues will just exacerbate differences, heighten controversy, make the situation worse. And in some situations, I suspect in terms of the emotional framework within which those issues were raised, that there's probably some truth to that. But it did resolve some issues. But more importantly, what it did is it teed up the issues for the political branches to actively engage them. And it's the seriousness, because it does take pretty profound seriousness to bring a case of the magnitude that climate change litigation would entail. It highlighted the extent to which this is a serious social problem that, in fact, the political branches of government ought to address. So it's important to think of litigation not just in terms of the actual, I don't want to be flip about this, because there actually has to be a case in controversy, and there actually has to be a real case. And so that's not suggesting that it be used lightly. But I want you to think about the role that litigation plays, right? Good faith litigation, and I'm assuming good faith on all sides, because I do think that unless you approach this with the notion that, in fact, there's a good faith disagreement on whether litigation is appropriate or not, the question of the role that litigation plays is one that I want to put over here, because I think that's in some ways a separate question from the specific litigation that's been proposed in the climate circumstance. So Peter's comments were I thought, quite telling, and they were quite telling to this extent. Not only did he highlight the improved science, but he highlighted the attribution science is where the improvement, it seems to me, was critical, because to the extent that you can tie it to specific actors, even if it's a group of actors, right, the possibility for ascribing liability is better. Now, the question of displacement, preemption, standing, justiciability, all of these are serious questions, absolutely serious questions. And the justiciability question, of course, looms large. And that's I think that the question of whether courts are even in a position to resolve the question goes to the heart of where the powers are divided among our government. That said, it's important to recognize at least the two kinds of cases that have been brought. The two kinds of cases that are currently in front of us are the Juliana case, the atmospheric trust litigation brought by our Children's Trust, the one that argues that the fundamental obligation of the government is to protect those things, those resources that are owned in common in an important way, and not only owned in common in an important way, but are necessary for the well-being of all of us. And so it argues that the government, and the important thing to remember about that case, just like the case that was brought in Holland and resolved favorably, well, it isn't that the court orders a legislature to do a specific thing, right? That no court, I don't think any court, will usurp the political processes and write a detailed climate change plan. Right? But the question in that case is whether a court can say, this is a responsibility you have as a legislature, and you've got to do something. It may not be something that the plaintiffs agree with ultimately, but you can't do nothing. Right? That's the core of that claim, is that you cannot just sit there with this problem that is in fact damaging human health, damaging a common resource, and do nothing. We may argue, at that point, we could argue about what it is that you do, but the obligation to act is plain. Right? And that then, in fact, tees up the political question, rather than claiming merely because it's something that ultimately has to be resolved by the legislature, it is not something that can be addressed by a court. The question of preemption and displacement, of course, for the state law claims are fundamentally different from the ones in the Cavallini case or the federal court cases. And there, my own guess is that the lawyers who brought those cases were very careful to bring them in the jurisdictions and in the form that they could not be said to be displaced by applicable state law. But of course, it will be argued. Now, the question of the federal, or the common law nuisance case, the public nuisance case is brought in California. There you have a state common law action, and the importance, I think, in thinking about the Juliana case and the California cases, there's this critical difference that I want to raise, because it goes to the question of remedy. That is, if you're going to ask a court to resolve an issue, as well pointed out, the fundamental question is there a remedy that the court can order? Right? Is there? Certainly, no court wants to find a harm that it then has no capacity to resolve. Right? So where the costs are open-ended, right? A court is going to be more loath to find liability because there's no end point, right? And so there's two basic approaches that the litigation has taken. One, in the California cases, and I think it's really important to note this, there you have actual sunk costs that have already been spent or proposed and budgeted but not yet spent, right, to address the actual harms that are caused by sea level rise. Right? So in New York, as they have plans now to address Sandy being the warning, saying, okay, in order to protect this city, we've got to do X, Y, and Z. Now, what exactly X, Y, and Z is going to entail, we can argue about that, and the experts, the scientists, the policymakers can argue about that, but you can actually put a cost on it. You can put a cost on it, right? So ordering if the attribution can be made, right? Ordering the liability to address those costs seems to be pretty plain. The other potential remedy is, I think, though, equally important, but somewhat more difficult. But merely because it's difficult doesn't mean that we ought to ignore it. Right? And that is compensation for natural resource damages. And compensation for natural resource damages is critical in two ways. One, because it is an actual loss. If you can identify the resources that have been lost, been damaged, been impaired because of climate change, gives you one way to think about the cost. But the other side of that, I think, is almost more important. Right? The other side is this: that if you're going to address the problem of climate change, climate disruption, and increased greenhouse gases, then the solution, the remedy, has got to be, it's got to speak to that problem, right? Not just compensation, but actual drawdown of carbon. So the question of addressing natural resource damages is the question that speaks to the obligation to draw down carbon loads. Because unless, if you look at the science, at least as I read it, and I'm not a scientist, I don't even pretend to be a scientist, but I can read it though. And to the extent that I understand it, and I recognize that I might have misunderstood it, right? But to the extent that I understand it, is that unless you actually get reductions in carbon loading, right, you're merely delaying the inevitable. So that one thing courts might do, right, is actually create a fund which can be used to produce those things that will help draw down carbon loading. Okay. So let me summarize. The first question about litigation. Is litigation the solution? Well, no, but remember I suggested there were multiple functions of litigation. And you need to understand and appreciate the multiple functions that litigation plays. Second, is it all going to be preempted by the federal government? The answer to that is no. That one of the advantages of a federal system is that, in fact, experimentation, even if it's experimentation through litigation, permits us to address the problem that the people themselves have recognized is a problem, right? And it's important for me to underline that, right? Because even though we've withdrawn from the Paris Climate Accord, it's clear if you count the numbers that over 90 million Americans have already taken action on climate through the Cool Cities program, through AB 32, and various other local initiatives. So the people themselves actually recognize that climate change is a significant issue facing us, and it needs to be addressed. One of the things that litigation does is it gives them another tool to do that. Finally, the question of I take this seriously, right? The reality is, of course, that to some extent we all are culpable. That's right. Right? I mean, one of the things that I'm coming here from Ithaca. Some of you may have heard of it. One of the things that exists in Ithaca, and it might even exist here in New York City, but I don't know. Right? Is every time I fly out of Ithaca Airport, I can buy an offset for the carbon that I use on the flight, and the money from that offset goes to finance to make poor people's homes energy efficient, to reduce the cost of energy to poor people. Right? It's called sealing the cracks. Right, and so my flights actually get to be used to help reduce the energy use of people in Ithaca who could not themselves afford to reduce their energy use. Right, because they recognize that energy is part of the problem, and we all use it. Right, but just because we all are part of this society doesn't mean that no one's culpable. Right? No one's culpable. Just because we all benefit from it doesn't mean that the people who are actually benefiting the most or who knew in advance shouldn't be held liable. Okay, I want to end with this because one of the things that was raised, it seemed to me, through the course of the discussion, and it's important to pull it apart and not to conflate it. And that's to be able to separate out those which are legal questions from those which are moral and ethical questions, right? Because because we know there's a moral defect doesn't mean that there's a legal liability, right? And so I hope the discussion helps us tease out where ethical and moral culpability bleeds over into a legal liability and how we ought to think about that problem. And why don't I leave it there? Okay.
Thank you all for your thoughtful comments and presentations. So we're going to have some time for Q&A now, and I think I'll get things started. And I'll start it off by trying to remap out what's been talked about, because we had a diverse range of presentations and thoughts. There are a number of different types of lawsuits that we heard about during the course of the presentations. Sharon presented a prospective RICO lawsuit that has not yet been brought, but that might be brought based on the arguments she was making about the analogy between the current state of affairs, the current knowledge of industry practices, where we are with understanding climate impacts, and what we knew about tobacco in similar situations in the tobacco context. There's the public trust litigation, which our Children's Trust has brought in states all across the country, and most sort of saliently at the moment in the federal court in the District of Oregon, where there was a decision issued by the district court judge the day after Election Day in 2016 that affirmed the substantive due process right to a stable climate system, a public trust obligation to combat climate change, and the possibility that the Equal Protection Clause protects current youth and future generations from climate impacts. That case is currently at the Ninth Circuit Court of Appeals, where petitioners, where the defendant, U.S. government, has sought a writ to have the Ninth Circuit get rid of the case, and we will see what happens with that. But that is a case against the government, seeking to have the government exercise its authority to combat climate change. And that's similar to other cases we've seen around the world, including the Agenda case in the Netherlands, and a case filed today in Ireland, where, again, a group of plaintiffs have brought a lawsuit charging the Irish government with inadequate ambition to combat climate change. We also heard about a range of common law cases, both at the federal level and the state level. And these include the federal public nuisance claim in the Connecticut versus AEP case and in the Cavallina case, as well as state common law claims, including public nuisance, but also others that we didn't really specify, including negligence, trespass, design defect, and false and misleading advertising, all part of some of those California lawsuits. Finally, Professor Torres raised the possibility of natural resources damages litigation, which is something that is not as often talked about in these contexts, but certainly presents another viable potential pathway to the courts. All of these legal arguments have legal defenses, and Tom brought some of these defenses to the front, right? We have political question doctrine, standing questions, causation questions, preemption questions at the state level, and displacement questions at the federal level. In addition to these legal arguments, there's a logic of blame at stake here, right? Or a logic of blame that's at play here. In some of the lawsuits that were brought in California, plaintiffs are seeking to hold a select group of fossil fuel companies accountable for climate change and to get damages, to seek monetary compensation for the damages that they've caused. One of Tom's points is that, well, it's very difficult to draw those boundaries, and it's very difficult to draw those lines. And that's true, and it matters for the legal cases, and it's true, and it matters for the ethical considerations as well. It's not as clear-cut, was the argument that Tom was making in regards to who really is to blame for these problems. At the end of the day, there may well be one or two of these lawsuits that gets through and makes its way to a finding on the merits, and this was a point that Professor Torres raised. And the question that we have there, and this is the question that I'd like to pose to our panelists to respond to, is what would be a just result? At the end of the day, we get a ruling on the merits in one of these lawsuits, and I'm not going to ask you to pick from among the 7 different types of lawsuits we get, but what would be a just result at the end of the day from the court? What's the remedy that does something in a just fashion to address this problem? Peter, I don't know if you'd like to get things started. This is not your area of expertise, but I know you think a lot about these things nonetheless. So. Oh, and I should say, when you're going to speak, you have to turn these on. There's a little switch.
All right. Unlike Gerald, who can read and understand science, I neither read nor understand law. So I don't want to try to pretend something that I. Anyway, let me speak to it more from an ethical than from a legal perspective, because it actually goes to the point that Tom was making about who's responsible. Because I want to, and therefore what a just outcome might be. Because and just take the public nuisance cases in California. From an ethical perspective, they're arguing that citizens are being held responsible. They're experiencing the damages. As taxpayers, they're expected to pay the costs of adaptation, which are not insignificant. And that's a microcosm of a larger societal challenge. That is to say, yes, we are all responsible and at a certain level, and we are all bearing the costs currently. But that there are institutions or companies who are distinctively responsible, as the case would be, because of what actions they took, that were not available as actions for private citizens. We use energy in our daily lives, as you highlighted, but we don't choose to use fossil fuels. It's that we have a limited palette of options by which we can make energy choices, precisely because of the decisions made by companies to avoid regulation of their products, knowing full well of the risks. So I would argue that currently the baseline assumption is that citizens, people, are blamed in the sense that they're being held responsible for the impacts that are only partly accountable from their actions, given that most of us don't have, some of us can afford plane flights and can afford to pay carbon offsets. Most people don't have the luxury of choice or access to information and know what choices to making, but that's not true of the companies. They have tremendous resources and capacity to make different choices. So in the public nuisance context, I do think that a just result would be that companies would be paying some fair share, and maybe the kind of quantification in the attribution work that we've done is one approach to monetizing the relative proportion of damages that would be associated with it. But ultimately, from my perspective, yes, and a just result is that the ability of these companies to thwart what I would argue is sensible restrictions on their dangerous products would be reduced, so that they're no longer able to be effective at constraining the U.S. political system, for example, from taking sensible actions to reduce the harms of their products. So I would put that as a very broad strokes, non-legalistic frame for what a just result would look like.
That's great. Thank you, Sharon.
Well, in terms of a remedy, I thought of several things that might be appropriate here. The companies the defendants, if found liable, could give money for research to solve the problems. I mean, research isn't any set of foundations or some way to put money into the situation so that research could be conducted by, scientists who are free from conflict. So it wouldn't be the companies get to go back and do their own research with some of their own scientists, but maybe some of those scientists might be part of ultimately this consortium of scientists that would do the work. Corrective statements. In other words, we were lying back then when we told you that stuff about, climate didn't matter, that doubt. Just kidding. I mean, corrective statements being ordered by the court. Now, I know that some of you are thinking, oh, what about the First Amendment? The First Amendment doesn't have a right to commit fraud. And if you're in a RICO case and you're found liable for fraud, this can be used to correct it. They did this in the tobacco litigation. Just last week got the corrective statements out. That's how long it took. We had disclosure of existing documents and research that the companies have and have possessed over the years, maybe where they stopped. We don't know because we haven't had disclosure of all these documents, what they were doing and what they know, that may help us in resolving some of these issues and may expedite some type of resolution to help the planet. Get those documents out there. And finally, the one that I thought about is some type of monetary payment. Let's look at the Kivalina situation, where those people lost their land, lost their homes. There have got to be other communities like that that could apply for relief in some measure that these companies, if found liable, would have to pay. That's all I could think of.
That's great. Thank you. Let's work our way from the outside in. let Tom have more time to think of how he's going to respond to something like this.
Rats. I don't think I have a chance to address his response. But those were actually quite excellent suggestions, although I do think that one of the issues isn't just to recognize culpability. It's difficult to prove, right? And there are, we can go through all the various causation problems of the legal problems, but it's actually to address in a fundamental way the harm that continued use at the rates that we're using are causing. And so what I would want to see as a remedy is, in fact, a company would say it would be a death sentence, I presume, right? But it would be research not just on the impacts of fossil fuel burning, but in fact research into the transition away from it. Now there's certain things, of course, I mean, that for which there's no substitute right now, right? We all use rubber, right, on the tires, right? Energy is the easiest one in some ways because you can readily think of substitutes for fossil fuels for energy. Take Texas, for example. Texas, which thinks of itself or likes to present itself as an oil and gas state, on windy days produces almost 28% of its electricity from wind. Right, so that even states like Texas have recognized through changing the portfolio requirements of their utilities can do this. They can still swagger and pretend they're oilmen, right? But in fact, they're windmen. So I would like to see some remedy that actually got us on the pathway to reduction, right? Just like the tobacco litigation. Tobacco litigation isn't just admitting that it causes these respiratory diseases and other cardiovascular diseases. It's actual process towards the elimination of the use of that product, right? That trajectory is what I'd like to be on the table for discussion, I guess.
Tom?
All right. I think all very valid points because I am here as the defense and I don't think the courts are really in a position to effect a workable remedy. I'm not going to say that any of these are actually workable remedies. But let me suggest some things. First of all, I want to knock something down. I was one of the people that argued the Clean Power Plan challenge before the en banc DC Circuit last September, the one where we're still awaiting a ruling, probably will never get one. But I want to note for you that no one in that case, no one challenging that rule argued that climate change wasn't happening. Okay? That to me is quite significant. We have moved a long way from the past decades. Most of the companies that I represent, utilities, are actually moving already towards new generation technologies. Gas is booming. Wind and solar are also. I'm sorry, did you want to say something?
Well, I mean, gas is a contributor.
Yes.
Gas is not a solution.
It's a step on the way.
We're going to hold off. We're going to hold off on that debate for a little bit. Let's let Tom finish.
All right. Fair. Everyone's good. Wind and solar are also. We'll put aside gas for now. Very good. But people are moving towards better sources of generation. And that is happening because of market forces. It's happening because of state renewable portfolio standards. It's happening because companies do business globally and they need to meet global challenges and market their products everywhere. The answer is more than just the United States these days. Two, I want to disagree with something that Peter said. Peter said we're all already suffering the damages from climate change. Now, I don't think that's true for most people. I think part of the problem here is that we're talking about something that's an externality, where you don't see in the short term the costs of your choices. Yes, there may be people whose property is affected. Maybe they've suffered a fire, maybe they've suffered from sea level rise, but most of us don't see this on a day-to-day basis. And I think one of the things that we need as a solution here is some sort of legislative fix, whether it's carbon pricing or something, so that we all see the actual cost of the energy choices we make so that we make better energy choices in the future.
Great. Thank you. Thank you all for your answers. Very, very good. So I think let's open it up now. There's obviously a demand for some questions and participation. We'll start here.
Yeah, let me ask.
Oh, I'm sorry, let me just ask you, when you ask a question, you can turn on your microphone in front of you. There should be a little button. And hold it up. This is being live streamed and taped, so that'll help. Thanks.
Yeah, the question is this. As far as attribution goes, the attribution of the health impacts of burning fossil fuels is much less contested and much more agreed upon and much easier to quantify than at the moment the impacts of climate change. We also know that because of discounting, if we look at like the present value of the monetized impacts of the health impacts are greater than climate change, although I understand the long-term issues. And we know that the oil and gas companies could, at greater expense to themselves, produce cleaner products that would have lower health impacts. Essentially, the additional cost would be like almost, it would work the same as a carbon tax. Given that the case for health impacts is so much easier to make than the case for climate, why don't we focus on the health impacts and on the non-greenhouse gas pollution as opposed to the climate change argument?
Peter, would you like to take first stab at that?
Sure. I guess I don't understand the premise of why it's either or rather than both and. That makes no sense to me whatsoever.
What we discussed tonight is climate change. What about the other impacts?
And it's absolutely legitimate to talk about the health impacts of coal, for example, and its impacts on mercury and particulates and all the health impacts associated with that all along the supply chain of coal, for example. It's hugely important, and the impacts are in fact devastating, and they should be addressed. All true, but I would disagree that the health impacts from climate change, both current and future, are negligible. I think that was the implication of your point, because they're not. I just showed you a study in which the health impacts of extreme heat, exacerbated quantitatively, shown on deaths from the European heat wave were substantial. Lots of other evidence of health impacts from climate change itself, including, for example, the impacts on the fires we're seeing in California and the impacts those have on air pollution, which is then the other health impact you highlighted. So there are a lot of impacts of climate change on public health, both current and projected. And there's a reason why we're focused on climate change, because the impacts are locked in for a long time, and the disconnect between the pathway that we're on and the one that, for example, is highlighted in the Paris Agreement, given the state of the science of those impacts, is extraordinary, and we need to wrap our arms around them now, not put them off to a future date.
I think that.
Tom, it's important to recognize that the current federal statutes, especially the Clean Air Act, right, is premised on human health as to set the baseline standards for compliance. So in some ways, the human health impact of air pollution, for example, or water pollution for that matter, were the drivers behind the legislation in the first instance. So one way to rephrase your question, if I may, would be should there, and maybe this is your point as well, should there be equal or maybe more attention to whether the standards that address human health under the federal statutes and state statutes that mirror them, whether there ought to be more focus on that, while we simultaneously try to address the problems of greenhouse gases and long-term change. But I mean, it's important for me to recognize that human health is what drove the initial pollution control statutes.
Okay. So what I'm going to do here is I'm going to take actually 3 questions all at once, and then we'll sort of answer them as we see fit. So hands up, please. We'll go 1, 2, 3.
Thanks. I want to comment on the political question issue, both the infringement, the claimed infringement on, say, congressional authority. This is an issue that Congress ought to address, as well as the question of the lack of clarity of the remedy that, or perhaps the abundance of choices of a remedy. And I would make the point that simply because Congress has the ability to address a question is not a legitimate basis for saying the courts shouldn't address the question. And second, that actually court decisions can have the salutary effect of causing other branches of government to address a question that they've been studiously ignoring. And so quickly an example, in 1973, the Supreme Court, in a divided 4-4 vote, upheld a district court decision that said that the Environmental Protection Agency had the duty to require states to develop plans for the entire country to prevent any deterioration or any significant deterioration of high quality air. They did that based on 3 words in the purposes section of the statute, arguably 1 word, the word protect. And they said protect means protect. And they didn't trouble themselves with the fact that they had no idea how to develop a remedy for this thing. They just said, we interpret the law to require this, and you go figure it out. Faced with that, Congress then enacted a multi-page articulation in a statute that actually created a program to address it. And I think, as Sharon said, litigation is good.
Thank you. Yes.
I can understand a court case based on falsification of data, but I was a little bit confused about how the court would perceive the credibility of what you call attribution science. Maybe I don't understand attribution science. It sounds to me like a complicated example of inferential statistics, which I understand to be as good as the data you collect and the model that you have behind it. And I don't understand it as a sort of standalone science. And I would like a little bit of commentary on how strong you feel that kind of data is, and whether the court, in its not always such great scientific wisdom, can accept this kind of data.
Great, thank you. And there was one more question up here.
I have actually 2 questions that are related. One is about recently there have been the Congress has been stonewalling nominees for the courts by the Obama administration in past years, and that has left some vacancies that will be filled for lifelong judgeships, presumably by the current administration. And I think some of the assumptions here were that the courts would be the same as they previously were, and that they would be somewhat unbiased, but there's a big possibility that judges who are appointed are not completely impartial. So addressing that possibility. And the other one was that I think there was mention from Professor Torres of the civil rights movement and litigation related to that, that prompted legislative fixes, and there are theories I'm aware from out of political science and social science research in related fields that suggest that really a key part of this whole process is social movements of people that then cause the courts and the legislatures to follow. And I was wondering if that could be addressed perhaps from the perspective of lawyers.
Thank you. So why don't we if it's all right, start with the social movements question, as it's fairly tailored to you, and then to the inferential statistics question. Then I'll ask you two to sort of address this declaratory judgment and whether that's an okay kind of end result at the end of the day.
I couldn't really hear the entire question, so if I don't answer it exactly the way you asked it, I beg your indulgence. The relationship between social movements and legal change is actually something I've been working on for the last 10 years, a long time. And my co-author, Lonnie Gumier, and I published a rather long piece on this. And Bruce Ackerman at Yale published a 3-volume book on how the people themselves produce legal change. So in the society we live in, right, there are formal ways to make law, right, but there are also various other institutions that have an impact on the way law is formally created. The transformation of the underlying or the background assumptions that underlie the institutions of which the formal institutions of lawmaking have a tremendous impact on, for courts, for instance, which interpretations are plausible. Okay, and if you trace opinions over time, you'll see some opinions that were implausible at time one suddenly become completely plausible at time two. And it's not that the judges have become smarter, it's that the background principles that arise out of the social relations themselves have made interpretation more plausible. I think the idea that there's a public trust, right? You can trace that back to Joe Sachs and his articulation of that at state law in Michigan, excuse me. And out of that insight, which of course ties back to Roman law, right? It's been reinvigorated as, in fact, part of our legal tradition, and it's what's driving the children's trust case. And I think it's the process of the people themselves acting, and which is why I made that comment about Americans actually being active in addressing climate disruption. It's that's important, because in some ways it will affect what things that may seem implausible now may make them more plausible at a later point. That's a bad answer to your question. I apologize. Rough answer.
It's a good, honest effort. Peter?
Sure. Is this on? So I appreciate the question on attribution science. I didn't obviously go into the detail in my short presentation. I'll refer you to a study from the National Academy of Sciences, the National Research Council, that came out a year or two ago that reviewed the current state of the science of climate attribution and identified that for particular kinds of questions, that is to say changes in the probability and the severity of particular kinds of extreme events, particularly extreme heat and precipitation, our ability to use climate models to look at historical conditions, to replicate the patterns that we've seen, and then to change those models or to alter them so that you can include or not include anthropogenic warming, or in the case of the study I showed, the subsets of producers, is quite robust. It's not so robust for other kinds of extreme events such as tornadoes or hurricanes, where the ability to attribute climate change to the changes in frequency or severity of some kinds of extreme events is actually quite modest at the moment, but improving. So this work has now been going on for about 15 years. It's a well-established body of science in the scientific community, published in a series of journal articles by quite a large number of researchers, codified by the National Academy, identified where it's useful for what kinds of questions or what kinds of extreme events, in a bounded way. Whether that becomes acceptable science in a court of law, I think is a question that one can ask, but I don't think it's unusual science in the sense that it's out of the bounds of the kind of now standard body of practice within the climate science community.
So there were two questions. Did you want to respond to that as well?
I just wanted to say that these are some of the similar challenges that we faced in tobacco litigation. Peer-reviewed. We use peer-reviewed science in order to support our claim, because the first time I heard the phrase attribution science, I had never heard of it either. And when I learned what it was, I said, well, that's really great stuff because it helps you with the causal link. And I do think that this is exactly the kind of information that you could use and you wouldn't have a Daubert problem. I mean, just based on my own experience, in looking at the report that was done and having had it explained to me more than once by real scientists, I think it's solid science and something that the courts would accept, but I also think that it will be challenged because it always is.
So there were two other questions that I'm hoping that you two will address about that are sort of more litigation, that are also litigation focused. One, sort of more of a comment about the role of declaratory judgments or remedies of various sorts that can force government action. And I guess there's a question there whether you see that as a legitimate and valid outcome. And then the other question about the identity of the judges. And I'll sort of shift that question around a little bit, if that's okay, to, in your litigation experience, how important is the identity of the judge or the set of judges that you're arguing in front of in making a determination, and will it matter here?
If I might, let me start by addressing your question, and I think you make a very good point about what the courts were doing when they were interpreting the statutory term protect way back then. And yes, that did force action. I think it actually finds an analog in Massachusetts versus EPA. The sort of core of our climate change cases. There you had the Bush administration saying, sorry, carbon dioxide, greenhouse gases, they're not pollutants, we have no authority to regulate. And the Supreme Court looked at the statute and what Congress passed and said, you know what, it does cover. Pollutant is a capacious term. It is as broad as you can imagine. The term welfare is specifically defined to include effects on climate and weather. And so the court reasonably, I think correctly, held that greenhouse gases are pollutants within the Clean Air Act. Now, what did that prompt? It forced EPA to act, because EPA then had a statutory duty to regulate. It still has that duty. As long as it concludes there is endangerment, it has that duty and it must fulfill it. But what makes that not a political question case, yours as well as Massachusetts, which was my case, is that Congress has acted. And what we have is the court fulfilling its traditional role of interpreting what Congress has done. These common law claims are what happens where Congress is doing nothing at all. It's unfortunate that Congress is doing nothing at all. The Clean Air Act has not been amended in any substance since 1990. It's 28 years old, for God's sake. It's woefully outdated. It doesn't deal well with climate change. I mean, I was asked to help draft the first set of climate grants, and we were trying to fit square pegs in round holes. What tools do we have? I laid out my options for the people I was talking to. I said, well, you can try to do an axe. That's not ideal, because how do you ever determine if an area is in attainment? You can try to do, an NSPS or an existing source performance area, and that's the route we took. Maybe there's section 115, who knows if that works at some point. But none of them is an ideal tool. What it takes is for Congress to identify a specific problem like climate change and craft a section of the statute, or maybe a new statute altogether to deal with it. This is what Congress did so well with acid rain way back in the 1970s. We need that sort of a solution for climate change. In the absence of congressional action, I don't know that you can latch on to common law to sort of force Congress to act, because that really is a political question. Congress should be acting here, and how are the courts to effectuate a remedy?
Sharon, did you want to?
Well, see, that's the beauty of a RICO case. You don't have to worry about that political action. You just have boxes to check. You can take the statute, block it out, see what you need to do, and move forward. It's just one big fat fraud case. So what if you do get a declaratory judgment in an issue, in a case? It happens all the time, where courts send the parties back to say, you go work this out. In that case, it went back to the district court. And then I'm sure the parties got together and worked something out, because it's nothing worse than having a decision by a judge that you don't think is going to give you the decision that you want. And in that situation, both sides feel vulnerable. Now, you said there was a question about identity of judges. And if you're looking at a statute in particular that has broad, when we filed a tobacco case, we looked at a number of different jurisdictions where we might bring the case, where there was precedent in that jurisdiction. We also looked at who the judges were in those jurisdictions. We don't get to pick the judge, but you do get to pick, when you're filing, the courthouse. And that was something that we looked at and paid a lot of attention to when we decided to file for a whole host of reasons in the District Court for the District of Columbia. As it turned out, that was a really good thing because the tobacco industry fought us on funding the litigation, and in those fights on the funding, there was a lot of travel associated with the case, but the case was local for all of us, and so that made it a lot easier. I mean, but people do look at the possible outcome. People are always, every step of any case that you file, and you're going through the months or years of that litigation, you're reevaluating your position, and it's being reshaped by the decisions that come down. You're learning how to communicate effectively with the judge that you have, whether it's one you originally would have selected or not. And if your arguments are solid and good, then if the judge won't protect you, that's what the Court of Appeals is for. I mean, you just have to go with it.
And I guess I want to make a distinction between non-justiciability, which is a real political question, and the idea that there's no yet explicit statutory hook. Because what the common law cases can do, of course, is to provoke action which then will produce the legislative response. And the simplest example is Shelley against Kramer, right? And we're all, to the extent that we all benefited from, everyone benefited or was burdened by climate change, right? Racial covenants. Right? Racial covenants are illegal in leases and in deeds, right? But of course, if I sell you a house and I have a racial covenant in my deed that says you can't sell this to this racial group or that racial group, on one level, right, a court would say, well, that's a purely private action, and it's not justiciable, right, because it doesn't violate any public norm that we have the authority to act on. What did the Supreme Court do? The Supreme Court said, well, yes, it's a private action, but you need a court to enforce it. And if a court enforces it, then that is the state acting, right? And now the state can act to say it can't enforce those covenants, right? So that there are, one of the things, as I said, the cases can do is they can tee up an issue so that the political branches act. That's what the PSD litigation did. It said, the Clean Air Act says, prevent significant deterioration. What does that mean? Well, it means prevent significant deterioration. We're not going to tell you, we the court are not going to tell you what exactly that means in every jot and tittle. But you gotta do it, and you can't let it happen, right? And so they did it.
So let's take a few more questions. We got 1, 2, 3.
Mr. Crumhoff, I'm sorry, I missed your talk, so I apologize if I'm asking a question that was my
Oh, turn on your microphone, sorry.
Hello?
Push the button that says speak.
His microphone's currently not available.
Oh, okay. Well, go ahead anyway then.
I'll try to speak just as loud as possible. Assuming everyone were to start driving Teslas, Leafs, hybrids, all factories were to go to hydroelectric, other non-fossil fuel sources, and America became 100% non-fossil fuel, what percentage in 10 years of the climate change damage would be created by Russia, China, India, other emerging markets that are continuing to industrialize and are not subject to our laws?
I'm just curious whether
Can
or
you
not there...
can you turn on your microphone?
I'm just curious whether or not there have been not very nice efforts to create immunity from lawsuits by energy companies. Is that going on right now? More bad news today? Can you tell me? Are they actually trying to do that as well right now? The way that tobacco companies try to make themselves immune from lawsuits?
Okay. Thank you.
The view posited by the defense in this somewhat case
Okay, so how shall we treat this? Well, there was a question about leakage. Was the first question. Peter, you want to take first?
Was that what the question was about? Well, thank you. It wasn't really about the topic of this session around company responsibility, but I'm happy to address it nonetheless. It's an interesting hypothetical. I suppose if we were to immediately transition into a zero-carbon economy in the U.S. and other nations were to accelerate business as usual path of carbon emissions, obviously the climate would be at great peril. And, of course, it's not the case that that's what's happening. In fact, quite the opposite. China is, I just can't help myself from saying this, is actually exceeding their Paris commitments. It's their investments, financial investments in solar photovoltaics as well as wind, but particularly with respect to solar, that have dramatically dropped the price of solar. That's made it feasible for solar to increase as rapidly as it has in the U.S. And globally. So it's a hypothetical which actually has no connection to the world as I understand it.
So there was a question about efforts to immunize industry from legal liability currently underway. I don't know if any of the panelists have a response to that. I do, but I'll defer to.
Well, I mean, you have a direct response. I would say probably, almost certainly. The science committee headed by Congressman Smith in the House, he holds an awful lot of hearings on so-called climate issues, and I've nicknamed him the congressman from ExxonMobil because he really is supportive of issues surrounding them. So they certainly have a presence there. What they're doing and what they're saying, I can't say. I don't know.
So the only thing I would add to that is that the question of a trade-off of legal liability for some other remedy, some other solution to the problem is something that's been talked about for a long time. And the question of whether basically people would be willing to, Democratic representatives and their constituents would be willing to trade off that prospect of legal liability in the courts for some solution to the climate problem has been talked about in academic and policy circles for a long time, and it is a conversation that is still ongoing. So let's take a couple of more questions. We'll go 1, 2.
I do want to address that question that came from the back, if you don't mind.
No?
Which is, what role does the political question doctrine play where you've got an inactive Congress or a Congress you don't like? I would say that those are precisely the instances where the judges need to be most respectful of the separation of powers, because it may be your Congress, the Congress that you like, that some other judge says, well, I don't like what they're doing, so I'm not going to respect what they're doing. Elections have consequences. Congress sometimes acts through gridlock, as little as we may like it, and as frustrating as that may be. I've spent 32 years in Washington, D.C. trying to make the system work, and it's terribly frustrating. That doesn't mean our Constitution isn't what it is, and it sets up separate roles for the Congress, and for the judiciary, and for the executive. And it's the Constitution that mandates respect for those unique roles, not our like or dislike for the particular Congress that's in office or president that's in office. It's unfortunate, but it's the best form of government that we got.
Justin, I'm sorry about missing that. Thank you for correcting me, Tom. Okay. 1, 2, 3. And in the interest of time, I'm going to ask you to just keep the questions short. We have about 7 minutes, and so to get 3 questions and 3 answers,
The question is for Mr. Lorenzen. I think your later statements sort of contradicted your earlier statements about whether we're all plaintiffs here. And no, we're not. And the reason we're not is evident because given that what we now know about climate science, people are changing their behaviors. And had the companies not been lying for the last 30 or 40 years, we very well might have been changing our behaviors 30 and 40 years ago and not be in the mess that we're in now. And we might be all using solar-powered buses instead of gas and so on and so forth. And in terms of how I got here, I walked. But, so that was just my point, that I don't think that's a legitimate part of the argument against any case that might be brought.
No, I understand your
Tom,
point.
can we hold off on the response? Sorry, I just want to take a few more questions. Here, yeah, and then you, yes.
I don't believe, I may be wrong, but I don't believe that there is a shading law in New York City, perhaps New York State. This somehow has a relationship to the laws that we're talking about, climate change. And I wonder if anyone has any suggestions legally about how to have a shading law come about. So if people spend a lot of money doing solar, they won't be shaded by a tall building on their solar.
Thanks. So you started off today's introduction with a global dimension of like how people who have contributed to climate change are the most vulnerable to the impacts. And this discussion today has primarily focused on national dimensions in how it plays out. And I was just wondering if you perhaps could speak about, or anyone else who feels compelled, speak about the international dimension of whether there can be, like through the International Court of Justice or wherever else, like any possible legal action to facilitate that kind of adaptation and loss of damage. Thanks.
Okay, thank you. So, Tom, sorry to have cut you off before.
No, I apologize for doing it. I understand your point. There are people that are right now uniquely damaged by climate change. They are maybe in an area that's affected by fires or coastal flooding. But we are all going to, over the long term, suffer the same effects. And this is an instance where it's like with tax policy. And I think the judges have the DC Circuit talked about tax policy being a classic political question before. We may not like tax policy, but you can't, as an individual, challenge it. Because it is something that does affect everybody. The same is true of climate change. We are all responsible for it. We all suffer from it to the same extent. Yes, there may be individual variations in the damage and when it's suffered. But it's a common problem. And common problems, the courts have generally said, constitute the sorts of political questions that are best left to the legislatures. This may not be ideal in your view, but it is the way the law has developed in this country.
So on the shading question, I'm going to ask you to just put it on pause and come talk to me afterwards, and I'd love to follow up on that. But let's take the international law question. Our conversation has been focused on domestic avenues of remedies, and are there thoughts about potential avenues of remedies or justice for international plaintiffs, either, I assume, in domestic courts or in some international forum, in your view?
Well, I'm not an international lawyer at all, but if we're looking at some of these climate change issues as human rights violations, that would suggest to me that there are some international courts that might have jurisdiction to consider some type of case. It's just, I don't know, that's all.
Peter?
So there's in the context of the Paris Agreement, as you may know, the kind of question of loss and damage in the intergovernmental process was left unaddressed by and large, that it was really not a place that the industrialized nations, the U.S. in particular, wanted to go. And obviously historic emissions by countries, by far the largest are from the U.S., and so therefore the largest contribution to current loss and damage will be coming from our nation, first among others. So that exactly where that heads in the context of the negotiations is very difficult to foresee. There are, I don't know the legal details, but for example, the Philippines Human Rights Commission is in the process of calling major fossil fuel companies to account in the Philippines legal context for their contributions to damages. So that's one of several efforts, initiatives that are very much in a fledgling state to think about holding companies accountable in other nations. I know similar cases in Germany and elsewhere, but I don't think they've moved forward very quickly. Others will know more of the legal details, but there are efforts underway.
I think part of it is the major contributors to greenhouse gases are the ones most responsible, and you fish where the fish are, right? So So that focus is right. I mean, the extent to which it's a globalized problem, of course, is represented by the attempted international agreements. But we've got to think about ways in which you could encourage good behavior by global companies. Short anecdote, really quick, about out of time, is I was working for the UN in Chile when we thought there might be a free trade agreement between the Southern Cone and the United States, and trying to draft a Clean Air Act for Chile. One of the things I tried to do was to get the American companies to get credit for cleaning up the dirty plants in Chile for their clean, where they were on tertiary cleanup in the United States. There's $1 spent cleaning up the plants in Chile buy a lot more clean air than the $1 spent in the United States. And I was basically attacked as an anti-American when my view is it's an airshed. And what we're going to do is we're going to reduce pollution in the airshed. So it gets balled up and complicated like that.
Okay. Well, we are out of time, so please join me in thanking our panelists for their presentation.